Thanks to the panelists today, and it's the last session before we get to hear Lina Khan. So if you guys get bored, I'm just gonna raise my voice and, or ask questions to you guys. But I think it's also a very interesting topic with AI and the shift in everything that it's causing, and it would be inevitable that it would also kind of bring up questions about antitrust policy and where are the boundaries, and how do we need to change certain policies? How does it interact with other non-antitrust concerns that we have coming out of the impacts of these technologies? So we have a panel today kind of to get three different perspectives. So we'll get Alessandro's perspective as an academic that studies privacy, and that's one of the big issues in digital platforms. And it's kind of even more so increasingly in AI. I don't know if you guys saw the latest ad from Claude that just came out a couple of days ago, where they're digging OpenAI about going after ads and using your information. So very timely for our panel. And then we'll also talk to Elena just to give us a little bit of the European perspective, because they have moved more quickly on certain regulations in certain areas, and given the high uncertainty, it's good to get that type of perspective as to how we're framing it and what would be the role of the antitrust. And then Sheila has been quite involved in a lot of antitrust litigation and works directly with a lot of businesses, so her perspective on how businesses are navigating through these changing times are going to be very, very useful, I think. Okay, so I was going to start with Alessandro, thinking through this notion of data and privacy, and it's not a new topic, because we've been dealing with the digital platforms and this data issues for a while now, but with AI, we're probably going to see a lot more. It kind of came into their training, which was using general data, but it's probably going to involve personal data, and you've written a lot about privacy and thinking of it as an economic good. And the question that I would have for you to kind of set the stage is, we all think we care about privacy, and everybody says we do, but there is this point that we don't see people paying a price for it. It's very easy when you have to put your money where your mouth is, not a lot of people end up doing that. So would you kind of give us a little bit of context on how we think about privacy as an economic good, and is the lack of, or what they call the privacy paradox, is that a market failure issue? Is it our inability to, or maybe there is no price for privacy, just people are not telling the truth? What's the economic framing and research in this area?
All right, thanks. That's a great question. There is lots to unpack there. So I'll try to go in order from what I believe we know, in a sense that we can say we have some degree of certainty based on available evidence accumulated through the years, and then decrease towards the areas where we know less and less, and where the debate is still more open. We do know that when it comes to privacy, information asymmetries are ubiquitous or endemic. Essentially, the core problem is consumers don't know when their data is collected, what it is used for, and what the downstream consequences are. We also know that pure notice and consent mechanisms don't address that information asymmetry problem. By this, I do not mean that we don't need privacy notices. Rather, I mean that transparency per se does not resolve the first problem I was mentioning. We know that there are externalities. Privacy externalities have been studied for over 20 years. They come in many different shapes and forms. clearly in a ecosystem where disclosures become the norm and powerful data oligopolies shape choice by changing and adapting the UI, the interface, the architectural choice in order to nudge towards more and more disclosure. Whoever tries to protect their data faces cost, which go from small to large to almost unsurmountable. What we know less is the downstream harm, meaning we have all these symptoms of a disease, we have information asymmetries, we have negative externalities and so forth, but there is lots of debate, both within economists and between economists and scholars in other fields about what is the downstream harm of this. Among my colleagues in economics, many claims that consumers are revealing their true preferences when they don't choose many privacy solutions, because ultimately the cost to consumers of privacy invasions is small. Scholars in other fields, such as the law, disagree. And actually, although I am an economist, I tend to agree more with the law scholars than my colleague economists. I believe that my colleague economists, to some extent, have developed some myopic view of privacy cost. They try to find only tangible cost, monetary costs, which apply to all consumers at large. Whereas I believe that privacy harm comes in many different shapes and forms in the data economy. There are some costs which are very small, but high likelihood. Whenever you go to a website nowadays, you have to spend a little bit more time, from a fraction of a second to a couple of seconds, because in the background, the trackers are loading. That's a tiny cost at a per transaction level, but it's when you calculate it across many consumers, across many websites visited, it becomes quite a substantial cost. And then we go from this low cost, high probability at the individual level to low probability, very high cost related to catastrophic identity theft, societal harm from misuse of personal information, and so on and so forth. And this is challenging for economists because we have essentially an aggregation problem. How can we aggregate all these disparate costs into one single function and say, well, you know, because right now we don't have enough protection, the consumer harm is X. It's very difficult to pinpoint that X, but that does not mean that the X is not large.
That's, we'll dig more into that in terms of this difference between the economists and the lawyers, but I kind of want to also introduce, ask a question to Elena that's probably been a bit more from the European perspective. You've taken a policy approach in Europe, and they've kind of been at the avant-garde of kind of putting some of the regulation and how we think about privacy and how we think about data, and now with new AIX in general. But in Europe, there's also a new movement of digital sovereignty, where we're thinking about, we need a European EU-based AI stack, and just wanted to get your perspective on this additional piece as well. How does it change the view from competition? So that's another edge that we're kind of facing into this antitrust space.
Thank you, Keller. I mean, I will have to do the usual disclaimer, so let me. So I'm here in my personal capacity, and nothing that I will say can be construed as reflecting the position of my institution. Having said that, I think, I mean, there is a lot in the question. I think a lot of dimensions in this panel, I think we're a bit challenged. There is it's kind of like all the other topics of AI concerns when it comes to regulation. And indeed, I think Europe has been active in, I mean, privacy, of course, GDPR, we have legislation that is generally applicable. There has been other movements, and I think Pier Antonio also told us about the DMA. There is this ex-ante regulation. And so if I take a step back and place it in the context of competition policy, which I'm most comfortable to talk about, I think that there is this question about how to apply competition policy to digital markets. and how it went, because I do think that in this respect, the fact that we had actually to put in place the DMA itself is a little bit of an admission of defeat, because the previous speaker on the first panel said the DMA is a little bit there to kind of fix the problems before they occur, before the horse has bolted. But I mean, no, the DMA is also here because the horse has bolted long ago and kind of, it's already going wild. So I think from this perspective, the question is, the objective of the DMA is actually to open the markets, and in our jargon to say, make them contestable, right, again. So something is not contestable, and the question is, from a competition perspective, I want to say the $1 billion question, but really more $1 trillion question since last year, is really what did go wrong, or is the competition sufficient or not sufficient, and what's the gap that the DMA or other legislation is meant to close when it comes to the objectives of competitive markets, I think. And so in this perspective, I would say maybe there are 3 points. I mean, one is maybe these digital markets, and I think there has been a lot of studies in this regard, have specific characteristics, in specifically the kind of network effects on steroids that give it great propensity to monopolize, right? So there is maybe something that was already like really hard to catch with the tools we had that is specific to the kind of market data economy and the digital economy. And then there is whether the rules we have are actually fit for purpose, and referring to something that Joe said also earlier, specifically coming to this algorithmic pricing age, which indeed now will be endemic, or so we expect. Like, is it still fair to say that a monopoly is only a problem if there is an abuse? Is it applicable to this endemic situation that we expect to come, this systemic pricing discrimination that is not the optimal one, as somebody kind of pointed out, not in this kind of perfect reattribution of the surpluses. And so are the rules actually adequate for digital economy? And then the third one is, or did we apply correctly the rules? Because we had, like, let's say the emergence of the digital economy, okay, it's a decade at least that became very prominent. And did we apply the rules we had? And again, I'm not saying something new. Again, Joe alluded to that, that we were applying kind of manufacturing economy models from the IO economics to this digital world, and did we apply it correctly? Did we use the right analytical tool? So is the problem in the analytical tool? So arguably, all three come into play, right? These factors, like maybe the digital economy has really very novel, specific challenges. The rules maybe are not exactly designed for them, and probably, and that's what I want to just basically say here, is that the analytical tool is probably something we should fix, because that's also going to affect us going forward when analyzing these concerns. And here, I want to again say that basically the antitrust, the competition tool, more so than in, I think, for example, privacy, where it's more a rights approach, I think, that we have than economic approach, in Europe at least. Basically, we have been relying on industrial organization economics, which is a sub-discipline of microeconomics. And the problem is that in practice, it was heavily skewed, in Brussels included, towards the Chicago school kind of interpretation of basically of IO economics. And here the problem, it was unavoidable that there will be an issue with digital markets. And why? Because obviously digital markets is all about vertical relationships and vertical harms, like much more than the traditional industry. And what does Chicago school say? That vertical is not a problem. So, I mean, the car crash was to happen anyway, right? I mean, so, and I think from there, you also can see that ironically, then the DMA is actually fixing a bit of these vertical harms, because it's addressing a lot of the vertical relationship in its enforcement. So I just, coming back then, indeed, I think onto this, it has this idea of restoring, actually, I mean, if not kind of managing, but restoring this idea that we are in this absurd market structure right now, in a way where basically a handful of competitors are deciding on the kind of life or death of their wannabe competitors in this, these gatekeepers, as we designated them. So again, coming back to the digital sovereignty aspect, which is yet another layer, again, that is now in this geopolitical reality we live in. We are concerned about this, and the conversation was there about, defense and but basically sovereignty specifically, just the ability to self-determine the space in which our citizens operate when they are experiencing or using digital services. Just to be clear, it's not a competition consideration. Like, it's not. Per se, right now, it's not. So, but personally, if I may, in general, I mean, I don't see how we could develop any form of European digital services if we don't actually address this in the European infrastructure, right? That's what we are discussing in this context of digital sovereignty, to have like layers and stacks of digital infrastructure. I mean, I don't see how we would be able to go there if that's an objective, and that would be an industrial policy objective rather than a competition policy objective, as things stand, legally speaking, right now, without kind of clearing the space, be it through breakups or through other, I mean, this is just business-wise, as a very basic business consideration. I don't know how you have a viable competitor that is European right now in this space. So that's why, again, I think it was very interesting for me to take the opportunity to normalize a conversation about breakups, not necessarily only from a competition perspective, but also because if there is a real determination, which, again, I start to read in the conversation about digital sovereignty, it's just, and it would be interesting to hear also the audience and you, I don't think there is a viable business model in this space right now for anyone.
So how would this interact, like a digital sovereignty aspect of it, with a competition policy? Would you enforce against US companies, or like downgrade them a little, let a merger through only between European ones? No, close an eye to data privacy violations for Europeans, but raise the flag for more American companies?
I really don't think that there is anything I said that leads in this direction of protectionism that you're implying. I think it's irrespective of which flag the companies that are kind of foreclosing this field carry. I mean, and again, I think it was mentioned in the DMA, the gatekeepers, there are 7 companies. One is included European, one is Chinese. It's not only American companies. So I don't think it requires any necessarily form of national preference. When we come to that, it's just the ability to roll out a product that is viable and that is not completely, basically either siphoned off in terms of profits by the gatekeepers or killed as soon as it reaches some threshold of slight nuisance to the big tech. So no, I don't think it requires that. I think it's just a consideration that I have, that if you want to have an European digital infrastructure, it's not going to fly on business terms under the context that we have now. Also, I want to say, for example, Joe was advancing something that is also discussed in Europe, this idea of public sector really going onto a public infrastructure in Europe. I mean, that's one of the considerations, maybe.
Yeah. We'll go back into this one more, but I just want to bring it to Sheila, that you worked with the digital companies and kind of represented quite a few of them, and now you're seeing all these kinds of trends and boundaries where we think about data, privacy, sovereignty. In this changing landscape with the changing technology, like, how are you kind of advising your clients in dealing with this uncertainty or navigating this space, and what are the most where are the boundaries of antitrust law that are being tested that you've seen from your practice?
Sure. Thanks for having me. Do you have a quick question for the audience? I'm asking your question with a question. Yeah. How many of you are lawyers? A fair number. Okay, good. Okay, just helpful just for the lingo I may use. Talk about per se versus reasonable. I don't know if everyone is up on all the lingo. So I have a similar disclaimer to Helena, that my views expressed do not represent in particular my clients, who have varying interests, obviously. And I appreciate the question. So one, and I'm a defense lawyer, just in full disclosure. I primarily represent large companies, and so there may be occasion where I will disagree or not be in alignment with Elena, for example, but that's what makes it fun. In terms of your specific question, maybe I start with just addressing. I think there's a one school of thought is that the current rules and regulations are not sufficient to rein in sort of digital platforms. And then there's another perspective, which is that, at least at a macro level, that we need more regulation, we need more enforcement, we need more rules. And I know that in certain spaces, certain of like these large companies, digital platforms, would actually maybe even agree in some respects that they would like more regulation. They say this a lot publicly with respect to privacy in particular, that they'd like to understand the rules better and understand what the rules are and how so they can order their conduct accordingly and ultimately not incur large fines or worse from violating rules that they don't know exist. That's not a uniformly held view, but there is I think a school of thought, some of the companies who believe that. But I think another pool of people think that the tools that we have, particularly in the United States, are sufficient to bring new causes of action, to bring cases in new markets. The Sherman Act has been around since 1890 in the United States, and it's been used throughout as our country and as our technology and as society has evolved over more than 100 years. And so there's a perspective that, and it's been, and that tool has been able to be adapted through case law. And our case law in the United States, we're a common law jurisdiction to adapt to new realities. And even the recent cases that have been brought by the various agencies, I think, bear this out. There have been wins and there have been losses, but they've been on both sides of the coin. There have been, agencies have been able to, they would say, to hold to account from their perspective digital platforms, others haven't, but they're utilizing these tools that have existed for a long time. And so that's a debate that I'm sure will resurface in this conversation, but it's something worth sort of flagging and bringing to the surface that there are different schools of thought on the extent of the need for new rules and tools. To your specific questions, which I will now answer, Keller, is I'm seeing a few trends, and I think probably one of the biggest ones that many people are aware of is the rise, the advent of both civil litigations brought by private plaintiffs as well as investigations in the area of algorithmic price inclusion, and there are many different terms that are used, algorithmic price fixing, or in different phraseology. They have been proliferating over the past few years across various industries, whether it be hotels or rental properties and other industries. There have been a number of cases, and one of the key issues that we're seeing is what standard should courts be applying to analyzing the allegations that are coming out of this litigation, rule of reason, balancing the pro-competitive benefits against the alleged harms, or whether it should be a per se treatment, meaning this conduct there's no pro-competitive benefit to this conduct and it's just illegal. And courts have really grappled with that. And I haven't kept a score of how many are on each side of the ledger, but a number of cases have determined that a rule of reason standard applies. There have been other cases on the other side, and these are like literally progressing through the court, so it remains to be seen where we land. So that's one thing, and so helping clients, and we'll talk more about that in detail, I think, with respect to that set of cases. How do we advise clients in this very sort of developing area of law? But that's one trend that we're seeing. Another is the continued efforts to bring enforcement actions against digital platforms, as discussed. And we can talk more about what we're seeing there specifically. And I would say thirdly, in the United States, at least, in the most recent administration, I think in the merger enforcement space, which, and there are mergers that are both in the platform space, but this has, I think, relevancy beyond just mergers generally, more of a conversation to be had around divestitures or consent, consent decrees or agreed resolutions to pending merger challenges. We're seeing more movement in that respect, and we can talk more about that trend as we go on. But those are some of my opening reflections.
Thank you. So I'll bring it to just to kind of put it together with, as we're thinking of, you mentioned this regulation and that companies would want some. Europe has put in some regulations, especially in this privacy space, which is kind of at the edge of antitrust, and we're going to kind of talk a little bit more with Alessandro about what does it mean when you have privacy and data also is reflected as market power, and what are the remedies on that side. But before we go there, like you've kind of studied the GDPR as an economist with empirical analysis. What's been your findings as to the effectiveness of it in kind of adding to privacy, or like thinking through about what it does to the dynamics of privacy markets? And then
Sure. I did empirical research on the GDPR, not on the privacy side per se. So we didn't measure the extent to which the GDPR was effective in supplying "quote unquote" more privacy, whatever that may be the metrics. Other scholars did it. What I focused was the economic effect of the GDPR, because before the GDPR was enacted, there were lots of criticisms, lots of antagonism against the GDPR from industry and from scholars, raising concerns about the significant economic cost and damage that regulation so extensive would have caused. There is certainly no shortage of studies that have attempted since the GDPR to show cost. But if you look carefully at that literature, you find first, most of the studies that find cost are shorter. They focus on a span of time following the enactment of the GDPR of a few months. Sometimes I've seen studies, published studies, as short as 8 to 10 months. Very few go over 1 year and a half, which means that the effect that they may capture is possibly just a short-term shock, the adaptation, rather than how eventually the market readjusts to a new long-term equilibrium. Second, some of the studies focus on intermediate metrics, which don't really ultimately affect welfare, and particularly consumer welfare, that much. For instance, many studies have focused on advertising effectiveness, showing that advertising effectiveness was reduced by the GDPR in certain contexts. And that is an interesting result, sure. But in a way, in an ecosystem which is the advertising ecosystem, which is predicated around, which is built around tracking and targeting, if you start changing things so that some segment of the population is less likely to be tracked and targeted, of course, you're going to find some intermediate effect in terms of that variable. What was of much more interest to me was to see the downstream effects on consumer welfare.